Good day, everyone, and welcome for another session of obligations and contracts. Last meeting, we have learned that the meaning of the three obligations. We have alternative, facultative, and conjunctive obligations. When we talk about alternative obligations, various prestations are due, but the performance of one of them is sufficient. And when we talk about facultative obligation, only one prestation, but the obligor render another as substitution. And we talk about conjunctive obligation, one whose there are several prestation and all of them are done. For the next topic, we will be dealing with Section 4, Joint and Solidary Obligations. That is Article 1207 to Article 1222. Article 1207. The concurrence of two or more creditors or of two or more debtors and one and the same obligation does not imply that each one of the former has a right to demand, or that each one of the latter is bound to render the entire compliance with the prestation. There is a solidary liability only when the obligation expressly so states, or when the law or the nature of the obligation requires solidarity. In general, when there is a concurrence of several creditors, or of several debtors, or of several creditors and debtors in one and the same obligation, there is a presumption that the obligation is joint and not solidary. Consequently, where the obligation is silent with respect to the nature or character of the right of the creditors or of the liability of the debtors, each of the creditors is entitled to demand only for the payment of his proportionate share of the credit, while each of the debtors can be compelled to pay only his proportionate share. So when we talk about joint obligation, one where the whole obligation is to be paid or fulfilled proportionately by different debtors, and or is to be demanded proportionately by the different creditors. So when we talk about proportionately, it is not as equal. So if for example, there is a 10,000 pesos and CX should have to pay 4,000 pesos, and CY should have to pay for the 6,000 pesos. So though they fulfill the obligation, but they are proportionately demanded from the creditor, and the amount is not equal. But of course, they fulfill the obligation, having render the said amount to the creditor. And when we talk about solidary obligation, one where each one of the debtors is bound to render, and or each one of the creditors has a right to demand from any of the debtors entire compliance with the prestation. So if there is a solidary obligation, for example, CX at saka CY, they are solidarily liable to the obligation. So if that is 10,000 pesos, CX may pay the entire 10,000 and X should have to demand a reimbursement coming from Y. Okay? And collective obligation presumed to be joint. If A is liable to B, for example, for 9,000 pesos, there can be no problem regarding the determination of the following. First, the person liable to pay. Second, the person entitled to demand payment. Third, the extent of liability of the debtor. And the extent of the right of the creditor. Now, there are exceptions. 3 exceptional cases or instances where collective obligations are solidary and not joint. So they are, first, when the obligation expressly states that there is solidarity. So when we talk about expressly states, it is stipulated in the contract. So kung nakalagay talaga sa contract that their obligation is solidarity, then that is one of the exceptions or instances that the obligations are solidary and not joint, because as a general rule, it is presumed that the obligations are joint. Second, when the law requires solidarity. So if it is expressly or it is stated by the law that, or it is required by the law that this obligation should be solidarity, then it is one of the exceptions that this obligation is where collective obligations are solidary and not joint. The third case or instance, when the nature of the obligation requires solidarity, and in all of these cases, each creditor is entitled to demand for the payment of the entire credit, while each debtor can be compelled to pay for the entire debt. We have here Article 1208. Article 1208. If from the law or the nature of the wording of the obligations to which the preceding article refers, the contrary does not appear, the credit or debt shall be presumed to be divided into as many equal shares as there are creditors or debtors. The credits or debts being considered distinct from one another, subject to the rules of court governing the multiplicity of suits. So according to this article, if the words of the content of if it is not appear in a contract, then it is presumed that it will be divided as many as equal shares as there are creditors or debtors. So kung wala talaga nakalagay, it should be divided equally. Solidarity not presumed. The presumption where there are 2 or more persons in the same obligation is that it is joint. So that is the general rule. And the reason is that solidary obligations are very burdensome, for they create unusual rights and liabilities. Solidarity between debtors increases their responsibility, while solidarity between creditors increases the right of each creditor. The law tends to favor the debtors in presuming that they are bound jointly and not solidarily. We have here joint divisible obligations. The most fundamental effect of joint divisible obligation is that each creditor can demand only for the payment of his proportionate share of the credit, while each debtor can be held liable only for the payment of his proportionate share of the debt. For example, si X at saka si Y, they borrowed from A 10,000 pesos. So they should have to pay 10,000 pesos itong si X at saka si Y. But on the 10,000 pesos, ang kinuha lang ni X is only 4,000 pesos. Tapos ang kinuha ni Y is 6,000 pesos from the 10,000 pesos. So technically, if there is a demand for payment, X should only pay 4,000 pesos and Y should only pay 6,000 pesos. So they will be held individually when it comes to the payment. So they will pay proportionate share yung kinuha nila sa debt plus the interest. Article 1209. If the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the other shall not be liable for his share. So for example, kagaya kanina, if si Y is not, if Y is insolvent, so she cannot pay, she or he cannot pay the 6,000 pesos, then X will not be liable to pay the 6,000 pesos. So only on his or her proportionate share. And this article speaks of a joint and divisible obligation. The obligation is joint because the parties are merely proportionately liable. Kagaya kanina na 4,000 and 6,000 for Y. It is indivisible because the object or the subject matter is not physically divisible into different parts. In other words, it is joint as to liabilities of the debtors or rights of the creditors, but indivisible as to the compliance. This obligation constitutes the middle ground between a joint obligation and a solidary obligation. For example, A, B, and C are jointly liable to give D a car valued at 240,000 pesos. On the date of delivery, A and B are willing to deliver, but C is not. So in this case, D has no cause of action against C for the delivery of the car because, or as a joint debtor, C is liable only for a proportionate part of the obligation, which is 80,000 pesos. Since the car is indivisible, no, ibig sabihin, you cannot divide the car because that is a indivisible property. The debt can only be enforced by proceeding against all the debtors for compliance is not possible unless they act together. And pursuant to Article 1224, the liability is converted into one for damages. So A and B and C will be liable for 80,000 each, or a total of 240,000, because there is one debtor or one one debtor na non-compliant of the said delivery. So itong si C. So if there is only one na debtor na hindi mag-comply, then of course, since the thing is a car and it could not be divided, so ang gagawin is action for damages na lang. So A, B, and C will be liable each for 80,000 pesos because that is a total of 240,000 pesos. That is the value of the car, without increasing the responsibility of A, B. So C, the unwilling debtor, shall be liable for damages to D for having violated the obligation. So itong si A at saka si B, since they are willing to deliver the car, they will not be held liable for damages only with respect to C. If A and B suffer damages by reason of the fulfillment by C, of the non-fulfillment by C, they may also recover from C. And should any one of the debtors be insolvent, the other shall not be liable for their share. So that is according to Article 1209. And they must wait until the insolvent debtor can pay. So ibig sabihin, if si C will not pay the 80,000 pesos, itong si A at saka si B will not be held liable for the payment of 80,000 pesos na hindi binayad ni C. So only A and B will only pay 80,000 pesos. So 160,000 pesos. So hindi na kailangan na kunin yung 80,000 pesos kay A at saka B sa payment na hindi binayad ni C. A joint and divisible obligation is, in a sense, somewhat midway between the joint and a solidary obligation. although it still retains the two fundamental characteristics of the former. So first, that no creditor can act in representation of the others, and the second, that no debtor can be compelled to answer for the liability of others. So that is a joint indivisible obligations. Now, what is the effect of breach? Since in a joint indivisible obligation, compliance can only be enforced by proceeding against all of the debtors, it is necessarily follows that if one of the joint debtors fails to comply with his undertaking, the obligation can no longer be fulfilled or performed. Consequently, it is converted into one of the indemnity for damages. So, however, the debtors who may have been ready to fulfill or perform what was incumbent upon them shall not contribute to the indemnity beyond the corresponding portion of the price of the thing or of the value of the service in which the obligation consists. So, for example, if the car is, in this example, 240,000 pesos, so si A, B, at saka si C are held liable since si C hindi na-comply. So, technically, hindi talaga ma-deliver yung car. All they have to do is to pay 80,000 each. So again, if C is non-compliant, si A at saka si B will only pay 80,000 each. Tapos itong si C, 80,000 pesos plus damages because he breached the contract or he breached the agreement of delivery. But A and B will only pay 80,000 pesos. Okay? Effect of insolvency of a debtor. When we talk about insolvency, yung hindi na siya makabayad. He has no capacity to pay or he is insolvent. Wala na siyang kapasidad na bayaran. Lahat ng mga utang o lahat ng mga debts na babayaran niya. Okay, if one of the joint debtors should be insolvent, the others, you have to take note, the others shall not be liable for his share. So this rule is of course logical because to hold otherwise would destroy the joint character of the obligation. So again, if A and B and C are held liable for 80,000 pesos each and C cannot pay the 80,000 pesos, C A and B will not be held liable for the payment of 80,000 pesos na hindi binayad ni C sa creditor. So only 80,000 pesos each lang si A at saka si B. Now, what is the interruption of the period of prescription? We talk about prescription, yung period kung kailan mag-arise ang isang certain obligation. If there are two or more creditors or debtors, will the claim of a creditor addressed to a single debtor or the acknowledgement made by one of the debtors in favor of one or more of the creditors be sufficient to interrupt the period of prescription? According to one view, since Article 1209 merely provides that the right of the creditors may be prejudiced only by their collective acts, it can therefore be inferred that should the act of a joint creditor be per se beneficial to the others, as for instance the interruption of the period of prescription, the act of one would be sufficient. And according to another view, the act of a joint creditor, which would ordinarily interrupt the period of prescription, would not be valid because the indivisible character of the obligation requires collective action of the creditors to be effective. If a written demand is made by one creditor only, the debtor upon whom the demand is made cannot pay to him alone. Payment must be made to all. Hence, the act of one alone is ineffective. It is submitted that the latter view is more logical. Article 1210, this is one of the important provisions of the Civil Code. the indivisibility of an obligation does not necessarily give rise to solidarity, nor the solidarity of itself imply indivisibility. So that is why pinamemorize ko ang 1210, because this is one of the important provisions in the civil code, particularly in the obligations and contracts. Now there are differences when it comes to indivisibility and solidarity. So indivisibility refers to the prestation, and it is indivisibility is different from solidarity. While solidarity refers to the juridical or the legal tie that binds ties. So technically, it refers to the contract or the agreement, while the indivisibility refers to the prestation, than to give, not to do, or to do. In indivisible obligations, only the debtor guilty of breach of obligation is liable for damages, while in solidary obligations, all of the debtors are liable for the breach of the obligation committed by a debtor. So you have to take note, nasa indivisible obligations, only one debtor, for example, A, B, and C, yung si C lang ang liable for damages because he is not compliant with the contract or compliant with the agreement. But in solidary obligations, kung hindi nag-comply si C, si A, B, and C are solidarily liable, so they will pay damages to the creditor if they are not compliant. So you have to take note of that. If there is a stipulation in a contract that you are solidarily liable, so ibig sabihin, dapat hindi ka na, you will not be confident na kung hindi makabayad itong si C, okay lang. Pero if it is solidary obligations, kung hindi nakabayad si C, lahat kayo are liable with the debts. Indivisibility can exist although there is only one debtor and one creditor. While in solidarity, there must be at least two debtors or two creditors. So that is the general rule. In solidarity, of course, they are solidarily liable. So there must be two debtors, two or more debtors, or two creditors. Another distinction is in indivisible obligations, the others are not liable. The others are not liable in case of insolvency of one debtor. So si X, si A, B, at saka si C. So if C is not compliant with the agreement, so A and B will not be liable. But in solidary obligations, the other debtors are proportionately liable. So again, for example, A and B are jointly liable to deliver to C a particular car. Here, the prestation is indivisible, but the liability of A and B is joint. We have what is called joint indivisible obligations. That is stipulated in Articles 1209 to 1224. If A and B oblige themselves solidarily to give the car to C, we have a solidary indivisible obligation. The obligation is indivisible and the liability of A and B is solidary. To put it in another way, we have solidary obligation, the subject matter of which is indivisible. A solidary obligation does not necessarily mean that the obligation is also indivisible. Thus, where A and B promise in solidum or in solidary to pay C 10,000 pesos, we have an example of a solidary divisible obligation. Now, if A and B are jointly liable to pay 1,000 pesos, to pay C 1,000 pesos, what we have is a joint divisible obligation, and money is divisible. So the rule stated in the above article is logical. Indivisibility and solidarity are not identical, and they may be distinguished from each other in the following ways. So first, as to the nature, indivisibility refers to the prestation which constitutes the object of the obligation, while solidarity refers to the legal tie or vinculum, and consequently to the subjects or parties of the obligation. Second, as to the requisites, plural, plurality of objects is not required in indivisibility, while it is indispensable in solidarity. So again, in indivisibility, so it is not required that there would be two or more debtors or two or more creditors. But in solidarity, it is a requirement. So it could not be dispensed with. As to the effect of breach, in indivisible obligations, when the obligation is converted into one of indemnity for damages because of breach, indivisibility of the obligation is terminated. In solidary obligation, when there is liability on the part of the debtors because of breach, the solidarity among the debtors remain. Article 1211. Solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. What is the effect of passive solidarity in general? So each solidary debtor, insofar as the creditor or creditors are concerned, is the debtor of the entire amount. However, with respect to his co-debtors, he is a debtor only to the extent of his share in the obligation. For example, A, B, C, and D oblige themselves solidarily to pay E 20,000 pesos as follows. A, to pay by installment at the rate of 1,000 pesos a month to start in July, and B, to pay in September, and C, to pay in December, and D, if E passes the CPA examination. Now in July, can demand only 1,000 pesos from A. A can also make a demand from B, C, and or D that 1,000 pesos share corresponding to A. But E cannot recover yet the shares of B, C, and D which are not yet due and demandable. Because again, in July pa, and then si B, they have to pay on September, and C to pay in December, and D kung makapasa si E ng CPA examination. Now, how about in September, E is entitled to collect from any of the solidary debtors the share corresponding to B, which is 5,000 pesos. So 1/4 of 20,000 pesos. And A 1,000 pesos or 3,000 pesos if A had not yet paid any installment. The shares of C and D are not yet recoverable. Why? Because si C at saka si D, C is to pay in December. And D, if E passes the CPA examination. So it is not yet due and demandable. Now how about in December? E can recover from any of the solidary debtors a share corresponding to C in the amount of 5,000 pesos, plus such amount from the shares of A and B, which have not yet been paid. And the share of D will mature only after E passes the CPA examination. If E passes the CPA examination, the obligation of D to pay 5,000 pesos arises. This amount can be demanded from any of the solidary debtors. Again, E is also entitled to recover all amounts which are already due and demandable and unpaid pertaining to the shares of A, B, and C. If the agreement is that E may demand the entire obligation from B in September, from C in December, or from D if E passes the CPA examination, then B is liable for 20,000 pesos in September less the amount. If any already paid by A and D, and C is liable for 20,000 pesos in December less the amount, if any already paid by A, B, and D. And D is liable for 20,000 pesos if E passes the CPA examination less the amount if any already paid by A, B, and C. So again, if it is a solidary obligation, they have to pay the entire amount. So kung may insolvent o isa sa kanila ay hindi makabayad, they have to divide that equally in order to fulfill the entire amount because they are solidarily liable. Article 12.12. Each one of these solidary creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. Article 12.13. A solidary creditor cannot assign his rights without the consent of the others. So technically, in the absence of consent given by the others, the solidary creditor cannot assign his right to a third person. The reason behind this prohibition is that each creditor represents the others and the assignee may not have the confidence of the original solidary creditors, considering that the assignee, after receiving payment, may not give the shares of the others. If the assignment is made to a co-creditor, the consent of the other creditors is not necessary. What is the effect if a solidary creditor assigns his rights without the consent of other creditors? So the answer to this question shall have to be qualified. If the assignment is made to any one of the other solidary creditors, it is clear that there is no violation of the precept stated in Article 12.13, because in such case there can be no invasion of the personal or confidential relationship existing among the solidary creditors. In Article 12.14, the debtor may pay any one of the solidary creditors. But if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. Article 12.15. Novation, compensation, confusion, or remission of the debt made by any of the solidary creditors or with any of the solidary debtors shall extinguish the obligation without prejudice to the provisions of Article 12.19. The creditor who may have executed any of this act as well as he who collects the debt shall be liable to the others for the share in the obligation corresponding to them. So when we talk about novation, it is the creation of a new obligation. And in compensation, it is the offsetting ng compensation. Confusion, meeting in one person's and the quality of the debtor and the creditor. Later on, we will discuss each one of the extinguishment or modes or causes of extinguishment of obligations. And the creditor who may have executed any of these acts as well as he who collects the debt shall be liable to the others for the share in the obligation corresponding to them. What is the effect of novation? Novation is a change or substitution of an obligation by another, resulting in its extinguishment or modification. either by changing its object or principal condition, or by substituting another in place of the debtor, or by subrogating a third person in the rights of the creditor. For example, see X and Y, X, no one, X is liable to build a certain building in favor of Y. Tapos si Y has also debt to A. So technically, si A is indebted to, si Y is indebted to A. So kung hindi makabayad si Y with respect to the building na kinonstruct ni X, so pwedeng sabihin ni Y na I will subrogate my obligation to pay the said building to A kasi may utang si A sa akin. So si X now will have to claim the said amount to A. So technically, si Y nag-novate ng kanyang obligation to A. Okay? Now, another example, A debtor and B, C, D solidary creditors in the amount of 30,000 pesos. If B validly condones the debt in the amount of 18,000 pesos, he shall be liable for 6,000 pesos each to C and D. If B collects 15,000 pesos from A, B must account for the 5,000 pesos share each of C and D. So again, the effect of compensation and confusion is a figurative operation of weighing two obligations simultaneously in order to extinguish them to the extent that the amount of one is covered by the amount of the other. Confusion, on the other hand, refers to the merger of the qualities of creditor and debtor in one and the same person with respect to one and the same obligation. So that is the confusion. What is the effect of remission? Though remission as defined is an act of pure liberality by virtue of which the creditor, without having received any compensation or equivalent, renounces his right to enforce the obligation, thereby extinguishing the same either in its entirety or in the part or aspect thereof to which the remission refers. Effect of payment to a creditor. So how about if there is a compensation? You're going to pay the creditor. If one of the solidary creditors is able to collect the entire amount of the debt from one or some of or all of the solidary debtors, the obligation is totally extinguished. Although there arises a consequent obligation on his part to render an account to his co-debtors. Under the law, he can be held liable to the others for the share and the obligation corresponding to them. 1216. The creditor may proceed against any one of the solidary debtors or some or all of them simultaneously. The demand made against one of them shall not be obstacle to those which may subsequently be directed against the others, so long as the debt has not been fully collected. 1217. Payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offer to pay, the creditor may choose which offer to accept. So for example, si X and the obligation is 10,000. Si X and Y, they are solidarily liable. So technically, si X can either X and Y can pay 10,000 pesos each. So the creditor may choose kay X and Y to pay the said 10,000 pesos. And he who made the payment may claim from his co-debtors only the share which corresponds to each, with the interest for the payment already made. If the payment is made before the debt is due, no interest for the intervening period may be demanded. When one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. 12.18. Payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. Example, if A and B are solidarily indebted to C in the amount of 1,000 pesos and the debt prescribed, ibig sabihin, naglapse na. If A nevertheless paid the debt, he cannot collect from B the share corresponding to the latter. Neither can A recover from C. When a right to sue upon a civil obligation has lapsed by extinctive prescription, the obligation cannot recover what he has delivered or the value of the services he has rendered. A and B are solidarily bound to deliver, for example, another example. If A and B are solidarily bound to deliver 10 carabaos to C for slaughter purposes, latter, the lawmaking body, passed law which prohibits the slaughter of carabaos. If A nevertheless delivered the carabaos knowing that the slaughter of carabaos is already prohibited by law, he cannot get any reimbursement from B because the payment was made after the obligation had become illegal. So after the lawmaking body passed the law na prohibits the slaughter of carabaos. Effect of payment by a debtor. Where payment is made by one of the solidary debtors, the effect is either the total or partial extinguishment of the obligation, depending upon whether the entire amount of the debt is paid or only part thereof. Once payment is made by one of the solidary debtors of the entire obligation, there arises immediately a consequent right of such debtor to claim from his co-debtors the share which corresponds to them, with interest for the payment already made. This right, however, is not available to a debtor who makes the payment after the obligation is prescribed or has become illegal. As a rule, the interest shall be computed from the time payment was made. However, if payment was made before the debt became due, no interest during the intervening period may be demanded. In other words, the interest shall be computed not from the time payment was made, but from the time the debt became due. Thus, if A, B, and C became indebted jointly and severally to X for 30,000 pesos, and it was agreed that the such debt shall be paid on December 1, 1966, but instead payment was made by A on June 1, 1965, he can demand from B and C only the share which corresponds to each in the obligation, as well as the interest thereon from December 1, 1966. Nature of right of debtor. It must be observed that under the law before the payment is actually made, the right of the solidary debtor to demand reimbursement from his co-debtor is merely contingent and conditional. Once payment has already been made, the right becomes real and existing. The old obligation in favor of the creditor is extinguished, but a new obligation is created in favor of the solidary debtor who made the payment, and there is therefore no real case of subrogation. Article 1219. The remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors, in case the debt had been totally paid by any one of them before the remission was effected. So if payment is made first, the remission or waiver is of no effect. There is no more obligation to remit. The remission is made previous to the payment and payment is made. Solutio indebiti arises. It is incumbent upon the debtor whose debt is remitted to prove the priority of the remission to the payment to release him from responsibility towards his co-debtors. And the purpose of this article is to forestall fraud whereby the debt having been paid, the creditor who does not stand to suffer any loss or damage remits the share of the particular debtor. The article also secures equality and justice to the paying debtor, inasmuch as the payment benefits his co-debtors. So for example, A and B are liable in solidum to C in the amount of 1,000 pesos. C remitted A's share. Subsequent payment by B of 1,000 pesos to C will not entitle him to reimbursement from A since the remission extinguished the obligation with respect to A's share. However, B can demand the return of 500 pesos from C under the principle of solutio indivisibility. If payment by B was made before the remission, A is still liable to B because the remission is without effect, the obligation having been extinguished already by the payment. Article 1220, the remission of the whole obligation obtained by one of the solidary debtors does not entitle him to reimbursement from his co-debtors. For example, A and B executed jointly and severally a promissory note for 2,000 pesos in favor of C, and C remitted the whole obligation out of regard for A. So when we talk about remission, it is a kind of mode of extinguishment of the obligation. For example, yan ang gidonate, no, ang whole obligation out of regard for A. So kung ang entire amount remitted or donate, no, ang pinaka-concrete term to A, ang 2,000 pesos. A here is not entitled to reimbursement from B since A did not pay anything to C. Alangan naman magkuha pa si A o reimbursement, no? Coming from B na hindi gi-condone naman, or ibig sabihin there is a remission naman. So if only 1/3 is remitted, ibig sabihin there is a remission of 1,300 pesos in favor of B, in favor of A. CB is still liable to C for 700 pesos. Kay 1/3 lang man ang gi-condone, or ay na lang nabayari ng 1,300. So in favor of A. So CB is liable pa rin for the 700 pesos because they are going to pay 2,000 pesos. And B has no obligation to reimburse A for the 300 pesos. Kaya tag 1,000 man dapat ang share nila out of 2,000 pesos. Because again, of B shares affected by the remission. For the same reason, now, there's no payment made by A. So, girimit naman, when we talk about remission, there is a donation or condonation na ayaw na lang tubayari itong 2,000, yung 1,300 pesos, ang 700 na lang, to A, in favor of A. So, technically, si B, as affected by the remission, there is no reimbursement no nga ihatag kay A because again, there is no payment made by A. Article 1221, if the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. If there was fault on the part of any one of them, all shall be responsible to the creditor for the price and the payment of damages and interests, without prejudice to their action against the guilty of negligent debtor. So kahit isa sa kanila was in fault of the delivery of the said thing in the solidary obligations, so lahat sila should pay the price in the payment of damages. And if through a fortuitous event, the thing is lost or the performance has become impossible after one of the solidary debtors has incurred in delay, through the judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraph shall apply. So again, if there is delay, even if it is fortuitous event, meron pa ring liability. But if there's no delay and there is a fortuitous event and the thing is lost, then there is no obligation. Effect of or loss or impossibility of performance. If the loss of the thing or the impossibility of complying with the prestation which constitutes the object of the obligation is not due to the fault of the solidary debtors, the obligation is extinguished. So, walay obligation. If the loss or impossibility is due to the fault of one of the solidary debtors, the obligation is converted into an obligation of indemnity for damages. But the solidary character of the obligation remains. The creditor can still proceed against one or some or all of the debtors for the payment of the price, plus damages, without prejudice to the subsequent right of the action of the debtor or debtors who paid to proceed against the guilty or negligent debtor for reimbursement. So this rule may be illustrated by the following example. A, B, and C bound themselves solidarily to deliver 30 cavans of rice valued at 3,000 pesos to X at a specified date. And the rice already been segregated at the time of the perfection of the contract. All of the 30 cavans, however, were lost through the fault of C. So what are the rights and obligations of the parties? Of course, any one of the debtors can, of course, be held liable for the payment of the price or value of the rice plus damages. So hence, if X decides to proceed against A alone, undoubtedly the latter can be held responsible not only for the price or value of the 30 cavans of rice, but even for damages. Kung si A pwede si A magbayad. However, once A has settled his obligation to X, kung nakabayad na si A, siya ang nagbayad, even though si C ang at fault, he can then proceed against the guilty debtor, C, for reimbursement of the entire amount which he has paid to X plus interest. Since C has default of the failure of the delivery of the cavans of rice, then after settling the amount, after paying the amount to C, kasi A naman nagbayad lahat, so pwedeng kunin ang lahat ng mga amount na binayad ni A sa guilty debtor, kasi C. So for example, if A paid all the amount of 30,000 pesos, 3,000 pesos. So lahat ng 3,000 pesos na binayad ni A, pwedeng kunin niya kay C. Or it is a must. No, na dapat kunin talaga kay C because it is to the fault of C na hindi na-deliver yung 30 cavans of rice. If the loss or impossibility is due to a fortuitous event after one of the debtors had already incurred in delay, again the obligation is converted into an obligation of indemnity for damages. But the solidary character of the obligation remains. Any one or some or all of the debtors can be held responsible for the price plus damages, but without prejudice to the right of action of the debtor or debtors who paid to proceed against the debtor responsible for the delay. Article 1222, a solidary debtor may, in actions filed by the creditor, avail himself of all defenses which are derived from the nature of the obligation and of those which are personal to him or pertain to his own share. With respect to those which personally belong to the others, he may avail himself thereof only as regards that part of the debt for which the latter are responsible. Defenses available to a solidary debtor. The creditor or creditors may proceed against any of the solidary debtors or all of them simultaneously for the payment of the obligation. But whether only or all of the solidary debtors are sued jointly, any solidary debtor may interpose against the claim of the creditor or creditors any of the following defenses. So we have three. The first, defenses derived from the very nature of the obligation. Second, defenses personal to him or pertaining to his own share. And the third is defenses personal to other solidary debtors. Now we have here exercise in the next slide, but we have here instruction. First, write your answer in a 1/2 yellow paper. So kailangan it must be a handwritten. All answers, arguments should be written only in front of the yellow paper. So hindi na kailangan ng back portion. After answering, take a picture and please send the answers immediately to my messenger. Not later than 5 p.m. September 29, 2023. So we have here the problem. A, B, and C borrowed 12,000 from X on June 1, 1966, and they executed a promissory note binding themselves jointly and severally to pay the obligation on June 1, 1968. For failure to pay, X brought an action against A for payment of the entire obligation plus interest. A interposed the following defenses. First, that B was only a minor at the time of the celebration of the contract and that such fact was known to X. And second, that X had granted an extension of 2 years to C within which to pay. Now the question, can A avail himself of the defenses? Second question, granting that A can avail himself of these defenses, what would be the effect upon his liability? Assuming that he can establish both defenses by competent evidence. So give your reasons. I will just give you 10 minutes to answer the exercise. And you can pause if you want to answer. You can pause muna the video. So we have here suggested answer. A can avail himself of these defenses under Article 1222 of the Civil Code. And there are 3 kinds of defenses which are available to a solidary debtor. If the creditor proceeds against him alone for payment of the entire obligation, they are first, defenses derived from the nature of the obligation. Second, defenses personal to him or pertaining to his share. And third, defenses personal to the others, but only as regards that part of the debt for which the latter are responsible. It is evident that both defenses interposed by a fall within the purview of the third. Another answer, since A can avail himself, second question, the answer to the second question. Since A can avail himself of both defenses, and since such defenses are not absolute but merely partial in character, undoubtedly X collect from A the following: 4,000 pesos corresponding to the share of A in the obligation, and B an amount equivalent to the extent that B had been benefited by his share in the obligation, applying the rule enunciated in Article 1399. Regarding the effect, if the effect of a contract consists in the incapacity of one of the contracting parties. As far as the share corresponding to C is concerned, X must wait for the expiration of the 2 years extension which he had given to C before he can collect such share from A. Okay, hopefully this is a 1-hour lecture, and kindly submit your exercise to my messenger.